with the next installment of the uncertainty series. Today, I'm talking to you about dealing with uncertainty in deceased estate matters, and in particular, the area in which actuaries are involved, which is the calculation of maintenance claims against deceased estates. My name is Valens, and I'm an actuary at Monroe Forensic Actuaries. I've been involved with Monroe Actuaries since 2013, and the last 3 years or so I've been specializing in deceased estate and divorce matters. I will be assisted today by Wendy Mupumbi. Wendy is one of our senior actuarial analysts and a student actuary, progressing well in her exams. Wendy has also been specializing in deceased estate maintenance claims and divorce maintenance claims. If you have a question at any time during the presentation or have a comment, you will see there's a facility for Q&A or for comments. Please pose your question under the Q&A section. Wendy will answer if she's able to. At the end of my presentation, I will also make some time to discuss any possible questions that there might be. If you have a question that we cannot answer briefly, please leave your email address as well. We'd love to contact you afterwards and give you a thorough explanation of whatever it is, what you might have been asking about. Please also note that everybody is muted on the presentation. It is just to preserve the bandwidth and to make sure there's no interruptions. And lastly, there will also be a survey at the end of my presentation, and we'd love for you to please complete the survey. The feedback is always very helpful for us. Thank you. So on today's agenda, we'll dive right in and look at what the requirements of the relevant acts are in terms of maintenance for surviving spouses, and then also maintenance for children. And as part of the discussion, we'll go into some of the elements of uncertainty, how the calculation works on our side, and also look at some of the component parts of the calculation. A very important part of the overall process of assisting somebody in a deceased estate matter is also to make sure that whatever lump sum they might receive at the end of the maintenance matter being completed is that they have proper financial advice, and we will briefly touch on that as well. Now, we all know the saying, there's only two things in life that are certain: death and taxes. I thought that is well known but a bit tired. And although we are very well aware of the seriousness of the matter when there's death in a family, and that we often deal with claimants who are bereaved or going through financial difficulty, I did find the insights of Marcus Aurelius quite interesting about smiling at death. And then also, well, it's worthwhile just reading his quote. It's death smiles at us all, but all a man can do is smile back. And then Winston Churchill's contribution to this great topic is in very much his own fashion: I'm prepared to meet my maker. Whether my maker is prepared for the great ordeal of meeting me is another matter. Humor aside, the acts that are in place in terms of dealing with deceased estate maintenance claims are logical and they're purposeful. Looking firstly at the Maintenance of Surviving Spouses Act, number 27 of 1990, it is clear that the lawmakers anticipated an event where a breadwinner might die and there is not adequate financial provision left for the spouse. This has relevance obviously today, and we find also maybe a previous generation where it was typical for a male to be a breadwinner and his spouse to not be employed, that it was paramount to ensure that the spouse will have adequate financial provision after the decease of the breadwinner. Looking at a short excerpt from the Act, and this is the part of the Act that governs the calculation of the maintenance claim, I want to briefly draw your attention to the most important factors that are raised in the Act. It says, in the determination of the reasonable maintenance needs of the survivor, the following factors shall be taken into account. Then going on to the amount in the estate of the deceased spouse available for distribution to heirs and legatees, the existing and expected means and earning capacity, financial needs and obligations of the survivor, and the subsistence of the marriage and the standard of living of the survivor during the subsistence of the marriage, and his age at the death of the deceased spouse. This is, for me, typical legal speak. I trust that attorneys are very comfortable with this, but just unpacking the requirements of the Act and our interpretation thereof for a moment. Our understanding is that the Act requires basically a complete assessment of the surviving spouse's current and future financial position and their reasonable needs. And we draw attention to this word reasonable because in our experience, we've seen claims where clearly the claim is not just to meet somebody's reasonable needs, but to try and maximize and get as much as they can out of the estate. And the Act is also clear that the estate is only liable to meet those reasonable needs which the surviving spouse cannot meet themselves. And as mentioned just now, what we've seen and what the Actuarial Society of South Africa has given us a practice directive on is we've previously seen in cases where a simple, almost a wish list of expenses are being capitalized on behalf of the surviving spouse, but none of the other requirements of the Act are being taken into account, and that will often result in a overly inflated claim, far more than what the intention of the Act was to make provision for. Going on to the Maintenance Act of 99 of 1998, just briefly looking at an excerpt of that Act as it pertains to the duty to maintain children. The duty extends to such support as a child reasonably requires for his or her proper living and upbringing, and includes the provision of food, clothing, accommodation, medical care, and education. The parents' respective shares of such obligation are apportioned between them according to their respective means. And our summary of that is basically that it is the parent's duty to meet the child's basic need, but it's not limited to the basic needs listed there. It simply states that it includes the provision for those specific items, and of course there are other relevant and legitimate items that one would also expect the parents have the duty to provide for. And again, in terms of the affordability clause, it simply states that the child's needs are shared by the parents in relation to what they can afford. I will not address parental support in the rest of the presentation, but it's just briefly worth noting we've only ever had a handful of calculations where parents were claiming from the estates of deceased children. And there's two bits of case law that I want to draw your attention to. The one is Smith versus Mutual and Federal, which states that, for a parent to claim support from a deceased child, one is that the child was providing support to the parent prior to their death, and number two, that the parent is indeed indigent, that they are needy and do not have financial means. And then I think the case law there is more strict than that for what the Act states for a child. And then in Westhuizen versus Stanley, it was also ruled that only the very basic needs should be provided for, being food, clothing, shelter, medicine, and care in times of illness. I'll briefly some background. The types of marriages, and this is not exhaustive, but this is the context of the claims that we calculate, that we work with, is and mostly my referring to this relates to what the surviving spouse will get from the estate, other than the maintenance claim. In community of property, 50% obviously belongs to the surviving spouse. Out of community of property with accrual, there will be an accrual calculation. We also do the accrual calculations if we are instructed to. It is a separate calculation to the maintenance calculation. We have estates where there's out of community of property, but there's a will involved. Then there's, of course, interstate estate. We do not see that a lot because that's typically very small estates and it's not worth the cost and effort to claim for maintenance, although we would often argue otherwise, but just from practice, it seems that those rarely require an actuarial calculation. And for all these, valid will may or may not be in place, except of course an interstate estate. But the single issue that gives rise to the most claims in our experience, and that's also under the next heading on the slide there, is that the spouse's share of the estate is inadequate. For some reason, the deceased did not make adequate provision for the surviving spouse, and then the Act makes provision for them to ensure that they can get their fair share from the estate. Some other cases we also see from time to time is obviously that the spouse's share according to interstate succession is inadequate. And one that we see quite a lot with second marriages is that a surviving spouse has lodged a maintenance claim, but unfortunately, as we see from time to time, that they are claiming more than their fair share, sometimes even trying to empty out the entire estate. And then the deceased might have other children who were going to be heirs in the estate according to the will, and they might contest the claim. And that's often when we are also called on to do a proper assessment of what a reasonable claim will be that complies with the Act. Instructions for maintenance of children. I know there's a lot of times where maintenance should be paid to children where an actuarial calculation is not used. We would argue that an actuarial calculation certainly adds value to the process in that we are experienced in assessing expenses and also making sure that the time value of money is incorporated in the calculation. Especially for young children, the time value of money could have a significant impact on the claim. For older children that might have only 2 or 3 years of maintenance left in terms of the requirement, a simple summation of expenses might be appropriate. But certainly for younger children, we recommend that an actuarial calculation is used. And often in cases where the will does not make adequate provision for children, is with divorced mothers and also with extramarital children. It's very rare that we see that a claim for a child is lodged when adequate provision has been made in the will for the child. Going on to the components of the calculation, I will briefly go over this. We cannot go too in-depth into the calculation, but if you really read the provisions that's made in the Act, it is, I think, fairly straightforward. And our calculation consists of the following components. If we look at the top of the slide, it's a capitalization of past and future expenses. So that number is really the number that tells us what this person is going to need to be able to sustain their lifestyle for either the period of dependency or, in the case of a surviving spouse, for the remainder of their life. From that, we have to subtract everything that they have available to meet those needs, which would be future assets, which are typically payments that you will receive, insurance or pension payments, either due to the death of the deceased or money that might already be in the estate, and all the other means. So it means their assets. An important part of a person's assets is their earnings capacity or their future earnings, and any existing share in the estate. And then from time to time, other adjustments might be made to the amount calculated. It's unlikely on our side. We have seen other actuaries where a marriage has been very short, 2 or 3 years maybe, and then often a second spouse will lodge a very sizable claim against the estate. And the argument would go that, you know, if somebody's been married to the deceased for only a year or two, full dependency have not been established, and the claim would be reduced. We think those reductions are very, very subjective, and we rather leave it up to the executor of the estate and to the Master of the High Court to assess what reductions should be made to the claim. So we simply stick to the provisions of the Act, and then other adjustments we leave up to legal argument or legal expertise. When we calculate maintenance, we have to look at two things. One is we have to compare it to the size of the distributable estate to make sure that the estate can afford this maintenance. And also, and I'll get into some more detail a bit later in the presentation, also to compare it to the standard of living prior to the death of the deceased to ensure that there isn't an inflated claim or overclaiming happening. The components of the child's calculation is basically the same as for the surviving spouse, but obviously only until age of dependency, which might be age 18 or 21. Typically, we also see where a child is going to study tertiary studies, older age might be specified, like 23 or 25. We often have that the child's calculation is purely the capitalization of expenses. Children do not yet have earnings capacity for the period of dependency, and rarely do have other assets from which they can fund their own expenses. So those calculations are typically far simpler. When we have a case where there's a mother and a child claiming simultaneously, we have found that it's also often better to do separate reports for the mother and child, simply because children's claims tend to be settled far quicker and there's less cause for dispute than for surviving spouses' claims. And we also recommend the same to expedite payment for the child's maintenance is to do a separate child maintenance calculation. So looking at the uncertainty we experience in maintenance calculations and determining maintenance claims, speaking as the actuary who does the calculation, the main sources of uncertainty for us is often that the instructions are lacking information. And we are trying to communicate with claimants and instructing parties to clearly set out what is needed for us to determine a maintenance claim according to the Act. But often there's a lack of information. It could be incomplete information, so only some expenses are shown, and also clarity of information. We sometimes get statements of assets that are 2 or 3 years old. Also a statement that certain costs will be incurred, but there's no indication of the quantum of the cost. And where we can, we of course try and apply our knowledge and provide reasonable costs or make reasonable adjustments to the numbers. But certain things we simply know. We don't know. We don't know where a child intends to study. Will it be in South Africa? Will it be overseas? Will they study at a university or at a college or a technikon? And those things are often sources of uncertainty and inaccuracy in the calculation. So we urge claimants to give us as complete and accurate information as they have available. Another source of uncertainty, as I've mentioned, is we see sometimes where a claimant just submits a list of expenses that's clearly not in line with their standard of living during the marriage, and the overclaiming, and this is providing some difficulty. Then we have to interact with the claimant and say, are you sure that this is correct? This clearly does not line up with the other information provided with us, or where we act as a counter actuarial report. Often this gives rise to a lot of debate and discussion around what the correct allocation of expenses should be. As mentioned earlier, your future earnings or your future earnings capacity is an asset, and often there's uncertainty regarding how much that is. With the road accident fund work that we do, we often get an industrial psychologist or earnings specialist report that states, what somebody is likely to earn in the future. In deceased estate matters, we rarely, if ever, get those reports. We often simply get a statement saying what a surviving spouse is earning currently and what their age is. On that basis, we might just increase their future earnings at earnings inflation. But for younger surviving spouses, it might be appropriate to incorporate an element of career progression or promotions and increased earnings in the future. Another issue that we occasionally deal with is assets with a vague value. Like I mentioned earlier, we sometimes get outdated asset values or statements. There's also other assets that it's hard to place a value on. For instance, a claimant might be a beneficiary of a trust, but it's really impossible to know exactly how much they can expect to get from the trust. And there might also be other illiquid assets or niche investments. We've had cases with art or jewelry, which is very hard to place an accurate value on those. In those instances, we still rely on the instructing party to give us their best estimate. We are certainly not experts in valuing art or jewelry or the like. And if they cannot provide a value, we will communicate with the claimant and see if we should employ the services of an expert valuator. The last, and it's not really a source of uncertainty, but our actuarial assumptions used in the calculation certainly addresses a lot of uncertainty regarding especially investment returns and inflation. And I'll speak a bit more about that in some upcoming slides. So getting into the actuarial calculation and the assumptions that we use, when we value the expenses, we have to look at what level of inflation an expense item is likely to increase in the future. And at this point, it's important to say that we discussed the actuarial assumptions at length in my previous webinar, the one about divorce calculations. The calculation here is similar to a divorce calculation. And if you want to see a lot more detail about these calculations and the assumptions that we use, please send us an email. We will send you a link to the recording of the previous webinar that will get into a lot more depth and a lot more information regarding how we determine these assumptions and what level of confidence we have in them. So briefly for now, just is that we use three inflation assumptions, being price inflation, earnings inflation, and medical inflation. And depending on the nature of an expense that's being claimed for, one of those inflations will apply. For most items, it's simply price inflation. But for items where earnings is the driving force of the expense, for instance, for a gardener or a domestic worker, or maybe even an expense like private schooling, where a large component of the cost is teachers' salaries, earnings inflation is a more appropriate assumption. And then in particular, medical inflation for medical aid and other medical expenses, there's a fairly long history of data showing that medical costs on average is about 2% higher per year than price inflation as measured by the consumer price index. For this reason, we also recommend that when we are instructed that individual expenses are clearly specified. It is not ideal if we simply get instructed that a provision should be made for, say, 10,000 Rand a month. It's far better and definitely in the claimant's interest to rather break down that 10,000 Rand a month and tell us how much is for each item of the expenses so that we can ensure that we use the right inflation. The next important item is the investment return. So when we've determined the future cost of the expenses, we have to capitalize them at a discount rate, which is the the investment return we expect a person can earn on a stable portfolio of assets after fees and tax. Again, in our other presentation for divorce calculations, we get into the rationale for using a stable portfolio. So I will not get into that in any detail now, simply to say that our current assumption is that the reasonable investor should be able to earn 7.59% per year after fees and tax. And that will give you a net discount rate of 2.5% per year for items increasing at price inflation. Understanding the net discount rate is simply that you will project something into the future at inflation rate, and we'll discount it back with the investment return assumption. So the difference between the investment return assumption and the inflation rate is about 2.5% per year, and that is really the number that matters and determines to what extent future costs will be capitalized or what reduction will be applicable. It's also worth noting that the 7.59% per year is approximately for 10% per year gross of fees and taxes. Obviously, on an individual basis, taxes won't be the same for each individual. This is a broad brush approximate number that we use for everybody. And of course, on an individual basis, in reality, they might experience slightly higher or lower returns. We can unfortunately not tailor-make a return for assumption for each claimant. The amount of work involved in that would simply make the reports and the calculations unaffordable, and it is general actuarial practice for us to use a single assumption for all claimants. And lastly, if we look at the future costs or expenses to be incurred, we've applied the element of inflation of these costs in the future, but we also have to look at the probability that these costs will be incurred. And that probability relates to the claimant being alive. And for that, we use life tables or mortality tables. And our current table that we use is the South African life table from 1984 to 1986 census data, table number 2. Again, in the previous divorce presentation, I go into some detail as to why we use these tables. Now, very briefly, looking at some key components of the calculation. First of all, the means of the claimant. The means refers to all the assets, debts and liabilities, investments and future assets. And the future assets are, of course, like insurance and pension benefits to be paid, current share in the estate that can be used to meet future needs. That's very important. So it's really like drawing up a personal balance sheet for the claimant, and all the assets and all the liabilities should be reflected on that balance sheet. You'll see below, I've just shown an example of what we typically get for a fairly young person. In this instance is the value of their vehicles, their investments, their house, and then also the value of all the debt against these assets, and then their net assets gives us the value that we will use in the calculation. If there's any doubt as to whether or not the asset or a debt or any other items should be included in the calculation, we advise people to rather provide it to us in the information pack, and we will help assess, what to include and what to exclude in the calculation. Earnings capacity, as mentioned earlier, it is actually a sizable asset, and especially for young people, it might be the biggest asset. For older people, and that's where we see also most of our claims is for people over the age of 45 or over 50. It is much reduced, but might still have a significant impact on the claim. Importantly, in taking into account earnings capacity, the question has to be asked whether or not it was the intention during the marriage for the spouse to work. Our current assessment is that even if the surviving spouse has a qualification and has earnings capacity, if it was never the intention for them to work during marriage, then that should not be included in the calculation. They should not be penalized for having a skill The intention is to make sure that provision is made for them as like the support that they would have received during the marriage. And also, as mentioned earlier, is that most of the cases, we simply ask what the spouse is currently earning, and we will project that number into the future at earnings inflation and calculate the capitalized value of the earnings after tax, and also taking mortality into account. If there's a young person or somebody who might experience a significant career progression, the services of an industrial psychologist or an earnings specialist might have to be employed so that we can accurately try and predict their future earnings increases and to arrive at the correct value of the earnings capacity. From time to time, we will also do a very simplistic earnings progression if it's appropriate, but it always comes with the proviso that we are not necessarily experts in that, and if there's any dispute, the services of a suitably qualified industrial psychologist or earnings specialist might have to be used. And lastly, in terms of the earnings, I've mentioned that we project the earnings into the future, apply tax, we apply mortality, the probability of survival, and we discount it to the date of calculation. It's also sometimes appropriate to apply contingencies, and contingencies is simply a percentage reduction from the value of future earnings to account for future uncertainties, such as periods of unemployment. People might go through personal trauma, sickness, other ill health or incapacity to work. And, those are sort of the eventualities of life. And for that, we apply normally a 15% deduction to account for that. In terms of our calculation, past earnings are obviously just actual earnings, and we are normally simply instructed by the claimant as to what the value of their past earnings was. The past year, of course, referring to the period between the death of the deceased and the date of calculation. The financial needs and obligations, and this is really the driving force of the maintenance claim. So that is the expected expenses. We allow for past and future expenses, as we allow for past and future earnings. And past expenses is simply a summation of the expenses, and we might convert them to date of calculation terms if a significant period since the death of the deceased has elapsed. And we have to subtract any provision that's already been made by the estate. So we cannot double compensate the person. If a provision has been made, then we have to subtract it from the claim. And the future expenses are capitalized, or the capitalized value of expenses to be incurred to maintain the standard of living. We do provide a template for expenses. We ask that people use it. Sometimes they do, sometimes they don't. But there are definite benefits to using the template, so we strongly recommend for claimants to use that. Some of the benefits are that we ensure, or there's a higher likelihood that all expenses are accounted for. Also, we group the expenses together, so it assists us in helping us to analyze the categories of expenses and to test whether or not those expenses are reasonable. And ultimately, it helps us to avoid people either overclaiming or also underclaiming. We have had instances where we contacted claimants and said, but listen here, it seems that you should be incurring certain expenses, but you are not claiming for them. And often they've just forgotten about it or didn't think to include them. So certainly, following this structured approach helps people to avoid not claiming enough. We also do some basic checks to ensure that the expenses provided to us are accurate. Some of these are absolutely clear. There are known costs, like the cost of a TV license or DSTV. Those are known numbers that we can verify. We also do reasonability checks. And the reasonability checks also aligns with the Act's provision that it should only be, expenses should only be allowed for to the extent that it supports the standard of living. that was experienced prior to the death of the deceased. So we will look at the percentage of an item, the percentage of overall expenditure. We would look at absolute numbers. For instance, if somebody claims 1,000 Rand a month in groceries, but 2,000 Rand a month in pet food, we will definitely inquire and just make sure that those numbers are correct. Maybe it should be 10,000 Rand in groceries and 2,000 Rand in pet food. We also look for missing items. For instance, we've had cases where somebody in their assets, they indicate they have a second home or holiday home, but in the expenses, they are not claiming for municipal accounts for the second home. It's again a case of something somebody forgot, and then us inquiring about it will assist the claimant to make sure they have all the relevant expenses accounted for. We also have some standardized assumptions. So sometimes we simply get an instruction that a replacement vehicle should be provided for, but no detail is provided. So then we will take the initiative and we'll assume, that the vehicle will have to be replaced every X years, and also what the value of the trade-in will be. Other items for which we do have standardized assumptions, and we definitely prefer the claimant to give us the actual number of what they expect to use, but at times we get a case where a child is simply told us, they want to go to university. And for those instances, we have standardized assumptions and the cost that we assume for university, which will include the class and book fees, but also cost for accommodation, meals, and the like. Regarding the standard of living, it is not an exact science. It is really something that we can do some basic checks on only to make sure that somebody is not claiming more than the standard of living implied during a marriage. So some of the checks that we do is we look at the after-tax household earnings. We ask for the deceased's earnings and for the surviving spouse's earnings and compare it to the size of the estate. We also look at an apportionment of earnings. Say a rule of thumb is to say the household earnings will be shared 2 shares per adult and 1 share per child. And we also look at the possibility that lifestyle was funded by debt. And our position is that the estate should not be liable to try and maintain a lifestyle that was funded by debt. And just as an example, and these are actual numbers from a case that we were involved in, and we had a surviving spouse. It was a second marriage for who claimed 138,000 Rand in expenses per month for herself and 46,000 Rand a month for her child. And the deceased's children from his first marriage contested the claim because his maintenance claims were in excess of 20 million Rand. The surviving spouse did not work, and IRP5s were provided to us, which showed that the deceased earned on average after tax about less than 600,000 Rand a year. And the estate, the entire estate, was only about 8 million Rand. So clearly this was a case where a spouse was trying to empty the estate and effectively, take more than their fair share and leaving the other heirs to the estate completely out of pocket. In this instance, we acted on behalf of the children from the first marriage, and the claim was repudiated, the 20 million Rand claim, and the claim calculated by ourselves was approved by the master. So it is, again, just a reminder and us urging claimants to pay attention to what they're claiming for and to not claim more than what the Act intends. And briefly, if we look at the calculation methodology for the expenses, it's similar to what we do with the earnings capacity. Is we look at the future cost of each item, the probability of survival, so the probability that this cost will be incurred in the future, and then it's discounted to the date of calculation at the investment return. And what we show on the screen here is simply an example of how we will list the expenses, how we will show the frequency of the expense. It might be that some expenses are annually or only once every 5 years, but mostly expenses are listed as monthly, and also the applicable inflation rate and the capitalized value of each expense item. And finally, we believe very strongly that claimants should obtain proper financial advice, and it's preferred that the services of an independent financial advisor is sought. Of course, tied agents and advisors that work for banks or large advisory firms, can give a very good service. Our view is simply that independent advice will always seek to sell the best product to their clients. But be it as it may, taking cognizance of the fact that most people will have to achieve an investment return on excess of 10% per year before fees and tax, means that you probably need some insight and understanding into investments to be able to achieve that return in the long term. A lot of people simply don't have those insights. Often the claimants are not financially empowered, or they're not knowledgeable in investment markets. They don't understand the risks they are taking or the risks they are not taking. And we certainly feel like a financial advisor adds more than their weight in gold in the process to assist somebody to make sure that they invest in the optimal assets and balance of risky versus non-risky assets, to both achieve the return that they need to achieve on their assets, but also to protect their capital. Financial advisors will also assist people in other ways to help them manage their expenses, to keep track of their expenses, to keep track of their investment strategy and review it if it has to be reviewed. It will also assist people to not be scammed or not to be cheated. A good financial advisor will certainly help you to invest in appropriate assets. We've had cases where people lost a lot of money because they acted based on fear, or were simply scammed into investing in assets that didn't provide the required security. And a financial advisor will also remove a part of the financial burden or the administrative burden that people incur, especially in a time post the death of a breadwinner. It is typically a difficult time for people, and a financial advisor will simply bring some calm decision making into the scenario. We will also hand over to Eddie Teron now. Eddie is a financial advisor and an actuary. Eddie is a good friend of mine and also a colleague. And Eddie will talk a bit more about financial advice and also about the services that he provides that I think might be useful for some of our clients and other claimants. Over to you, Eddie.
Willem, thank you very much for that introduction. I'm just busy getting my screen onto the view so that everybody can see. And morning to everyone. I hope you enjoyed that presentation from Willem. Certainly it's insightful for me. Let me introduce myself. My name is Eddie Teron. I'm an actuary alongside Willem at Monroe Forensic Actuaries. And my passion is all things investment. And I really have a heart and a passion for helping people and giving them good, professional, sound, financial, and specifically investment advice. So to this end, to be able to do this under a license, I've set up a business called Convergency Wealth, which is a 100% independent business, meaning it's both independent from Monroe Forensic Actuaries, where we're on both sides very serious about client confidentiality and just making sure that there's no conflicts of interest. But then also independent from the point of view of supporting different product providers when it comes to physically investing the money. So as Willem mentioned, the need for a financial advice post a settlement, a payout after the death of or in a deceased estate scenario is paramount. And I just want to take 5 minutes to just take you as a deceased estate attorney. I'm assuming that's most of the audience today. Just take you through a concept which I'm hoping will make your life easier, but also then ensure better outcomes for your clients. So the way I'm going to do that is just to talk through the process, how I understand it, how a client usually comes to you, the deceased estate attorney, and then the process that you follow while you are engaging with that client. And then I'm going to look at that process, what it could look like with the introduction of what I call a personal actuary, which is actuary or actuary and financial advisor coming alongside you as deceased estate attorney to help you through the process. So let's look at what the process typically looks like. A client would come to you as the attorney, and then there will be many interactions between you and the client before an actuarial report is instructed. Then you as the attorney will instruct the actuary, and then again there might be interactions between you and the actuary to understand what information should be provided to the actuary. And in that process there might be more interactions between the attorney and the client. And then when the attorney receives the report back, then again there might be questions back to the actuary, and then there's a need for the attorney to go and explain to the client what is in the report, and based on that there might be some further interactions needed with the actuary. And then the big question, once a settlement has been arrived at and a claim has been paid, what to do with the capital. So let me talk through that same process with the introduction of a personal actuary. And what I mean by that is someone like myself with the experience of being an actuary and a financial advisor to be able to come alongside you as the attorney even before the instruction is given to the actuary. So let's look at the process. So the client contacts the attorney as normal. Then the attorney could contact someone like myself who works in partnership with you as attorney all the time. But I can then, given my knowledge of what goes into the maintenance actuarial calculation, I can then help you and the client get everything ready in the format that the maintenance actuary requires to then be able to submit that instruction to the actuary. So immediately there, it just makes it easier for you as attorney. It helps you and the client understand what is needed. And then once that instruction has been given to the maintenance actuary, Willem, when the report comes back, again, it would be myself who would be very well placed to explain the content of that report to the attorney and to the client. Especially also when it comes to as part of negotiating the settlement, when it comes to understanding the different nature of investments or capital that is going to be provided. For example, some assets might have a higher value than other assets after taxes deducted. So it's important for the attorney and the client to understand this before an agreement is reached on how the capital is going to be paid out. And then the thing that I'm most passionate about is then, once that capital has been paid out, is then to come alongside the client and get an understanding of what that client's desired lifestyle is. Obviously, we would have an idea based on the calculation that was performed, but then to be like a coach and a guide alongside that client to help them invest the money in a way that lasts and that does not run out. That's a very quick introduction of the services that Convergency Wealth can provide to you as an attorney. If you're interested to find out more, please send me an email or just give me a phone call, and I'll be happy to talk you through the process. And with that, I'm going to hand you back to Willem, and I wish you a good day. Thanks.
Thank you, Eddie. I trust that our clients will see that there's certainly a lot of value to be added by a reliable and knowledgeable financial advisor in the process and in the claimant's lives. We've come to the end of our presentation. Please, if there's any questions, make use of the Q&A facility. I will also give a minute or two for us to answer questions on air now. And at the same time, while we're waiting for any questions, just also our contact details. So if there's any questions later, please do email us at actuary@munrofa.com. Also, we do make recordings available of all our sessions. So if you want to see a recording of any of the other sessions, please also contact us so that we can send the link to you. Thank you very much. Appreciate your time and hope you have a lovely day. I will quickly address one question on air. We will also send an email to the person who's asking the question. The question is how are calculations made in case of a cerebral palsy child when it's difficult to obtain medical records from the hospital? Or can there be a calculation, if any, in such a case? In terms of as it relates to maintenance of the maintenance calculation against the deceased estate, we find that the information is normally provided to us because those costs are already being incurred. It's not a future cost. It's not the same as for a medical negligence claim. But if the costs are not available, experts' reports can be sought from the relevant medical experts. And also in these cases, the child is typically, maintenance is calculated for life because they will never be financially independent on their own, but an appropriate adjustment will be made to the child's mortality experience. So the claim will be less than for a healthy adult. I trust that answers the question. And with that, we're also going to end the session. Thank you so much for your attendance. Thank you.